Let's proceed. Paragraph 28. Before 28, which is our conclusion, go to 29. What are you saying? Why you want to detain him?
Is a police officer attached to that station, and if released can interfere with investigations and tamper with evidence of the station.
Have you attached any evidence showing attempted interference?
But I did depend in my statement. I did depend in my statement that there were interference.
We are only asking a simple question.
Yes.
You deponed because you have material that made you depone. Have you attached those materials before the court? Is either yes or no?
No.
Thank you. Paragraph 30. What are you looking for? Paragraph 30, another reason?
Other witnesses.
Huh?
The investigation is an applicant needs to interview other witnesses, including police officers from the station. And the respondent, being a police officer, if released on bail, is very likely to interfere with and influence the witnesses.
You are saying you want to interview police officers?
Yes. And
we'll go one by one.
Okay.
The first limb is that you want to deal with the police officers.
No, other witnesses.
There are other witnesses.
Yes.
And you have identified some of them are police officers.
Yes.
And confirm his rank is just a mere police constable. He has no authority over any police officer in this country.
I can't say that for sure, because what I've deponed in my statement is that this thing was planned and
we have
executed.
not reached there. Let us go systematic.
Yes.
I've asked a simple question, that he will interfere with police officers. And I've asked you this question. The lowest rank in the police, National Police Service, is a constable. And that constable has no power over any other.
Some of my witnesses are also constables. The same rank with him. He can influence them.
He can't
That is the point I'm
influence
making.
them. Have you produced any evidence to that effect?
Not.
Thank you. Let's move to the next one. He says, he is likely to interfere. Have you put anything to show that?
As an attachment?
Yes.
No.
We'll be concluding that that is apprehension later. Let's move further. Look at paragraph 31.
Yes.
What are you telling the court?
That the crime was planned, executed due to the seriousness of the offense, and the completeness of the investigations will require more time to carry out investigations.
This is a very serious crime. True?
Yes.
Is there any crime that is lesser than any other crime? Under what parameter do you decide this is a serious crime, this is a light crime? Have you provided that?
The sentences imposed, that the sentences that each offense carries actually show the seriousness.
Kindly confirm that this is an offense of murder.
Yes.
Which carries what sentence?
Up to mandatory sentence of death.
You are aware murder suspects can be jailed even for 1 day?
Yes, depending on the discretion of the court. But it carries a maximum sentence of death.
Let's proceed. Paragraph 32. What are you telling the court?
Key witnesses are police officers wielding police powers who from key persons involved are police officers wielding police powers who have engaged in a web of complex cover-up, employing the blue codes of silence, and will require time to unravel the complex web through conduct investigations. And if released on bail, the respondent is likely to interfere with investigations.
You have said the police, the National Police Service, roughly as how many police officers?
I'm not sure.
Roughly.
100,000?
The whole nation.
I'm not sure.
There are more than 100,000. And you confirm that they have a blue code of silence. Read that.
I'm talking specifically about this case.
I've said,
Yes.
look at that statement.
Key persons, you know, the word.
Just a minute.
Yes.
Because some words are serious.
Yes.
You confirm that the police have a blue code of silence.
I'm talking about specifically on this matter. Key police are involved. That's what I'm talking about. I'm not saying the entire national police.
Asking,
yes.
Because this is an affirmation.
Yes.
And it's a very serious affirmation.
Yes.
When the whole national police service is being said that they have a blue code.
Council, please do not mislead the court. There is no way in my affirmation we have indicated the whole national police service.
Where is that document, that code? The blue code. Have you attached it? A code is like this criminal procedure code that exists. And that is why I'm asking a very hard question to you. You have alleged that there is a blue code of silence.
Yes.
And you have put that it is an organized offense, according to that paragraph, and all police officers have agreed to be quiet.
You are misleading the court.
Explain. Explain.
No, it's not.
I might be wrong.
Yeah, you're actually wrong because that's not what my friend says.
Yes, please.
Allow me to interject. I think counsel needs to focus on the paragraph in question. He has repeatedly asked the question and it has been answered. Now he is attempting to one side, or rather to lead the witness in the manner in which he wants the witness to respond. Let him attack the paragraph specifically. The witness, the officer has stated clearly that he's specifically dealing with this case. If counsel knows of any other code, then he can do that in his submissions. But the witness has stated it specific to this particular issue. So let him avoid putting words in there.
I'm very specific to this case. I'm not talking of any other traffic offenses or sexual offenses. In this case, it is evidence that the National Police Service has taken an oath called the Blue Code of Silence.
No.
Objection. He has not stated anywhere.
Yes.
He has not referred to the National Police Service. Let's be clear, that is a serious assertion.
Your Honor, the paragraph starts in paragraph 32 that moreover, because key persons involved are police officers, wielding police powers, who from preliminary investigations have engaged in a web of complex cover-up employing the Blue Code of Silence. He has started by saying it's a multiplicity of police officers wielding power, and that they're using the Blue Code of Silence. And that's what I'm putting him to task. Does he have evidence that from the Inspector General downwards, by rank and by name, anybody is doing that Blue Code of Silence? Simple.
I think yes answered the question, but if it was not answered, it was to you. Maybe you can frame it in a different way.
I'll come back. I'll come back. Let's go to paragraph 33.
Yes, Your Honor.
What are you saying in paragraph 33?
The matter has elicited considerable public anger and outrage, as made apparent by demonstrations held over the matter. Therefore, the safety and security of the respondent may be imperiled if he is released on bail.
Read paragraph 34.
The court can take judicial notice of the fact that this matter is of great public interest. There is an outcry from Kenyans from all walks of life, including the Senate, the National Assembly, and even the President of the Republic.
So, this matter has been discussed in the Senate, true?
Yes.
This matter has been discussed in the National Assembly.
Yes.
The President of the Republic of Kenya has also talked about this matter.
Yes.
Go to paragraph 3.
Yes.
Tell the court your mandate and your powers under paragraph 3.
IPOA is mandated to investigate any death or serious injury, including death or serious injury while in police custody, which are the result of police action or were caused by members of the service while on duty.
Confirm that IPOA is an independent constitution.
Yes.
It is a constitutional entity that does not take directions.
Yes.
Other than from the DPP.
We don't take direction from DPP.
When you forward your file,
yes,
the DPP either approves or recommends further
yes,
directions.
Yes.
That is the only office that you can deal with. Is it evidence that you are not acting out of your mandate, but you are acting out of the discussion in Parliament, Senate, and the comment by His Excellency the President?
We are acting as per our mandate in section 6, 7, and 5.
Is that paragraph supposed to be there? That's what I'm asking. Does it add any value?
What we wanted is the court to take judicial notice of what is happening in this matter.
Well, almost the last paragraph. Paragraph 36.
Yes, Your Honor.
What does it say?
He was arrested on 12th of June 2025 and placed in custody at Capitol Hill Police Station, and he has been brought to court in accordance with the provision of Article 49(1)(f) of the Constitution.
When was he arrested?
Yesterday.
Kindly. Did he attempt to run away at the time of arrest?
No.
Where exactly was he arrested?
At ACK Annex Gardens entrance.
Which is the headquarters offices of where?
IPOA.
Was he brought under handcuffs or he walked himself there?
Allow me to explain this.
Yes, that's it.
The previous day when he came to record his statement,
Yes.
we were supposed to detain him actually, but because of the counsel that accompanied him, requested that we allow them, they go and he comes back to this phone the following day. So we agreed on a time at 8 a.m., which he never honored. So by the time he got a wind that IPO have now want to arrest him, so he brought himself without being arrested.
There anywhere in your averment saying that what you agreed was not complied?
I'm under oath, and I've stated the truth to the court.
Is there anything showing what time you required it?
He was present with his advocate. Can confirm.
And you confirm that he came himself?
He was with an old man.
With the?
A relative, I think.
A relative. And you locked him?
We arrested him because he got a wind.
That's what I'm saying.
Yes. He got he brought himself because he got a wind that we want to arrest him.
You want the court to believe that IPOA's information, people can leak that information?
The same was stated.
That's scaring to Kenyans.
No,
if somebody can know what IPOA intends to.
No. We publicly stated in the parliament that 3 arrests will be made.
You give the names?
I don't remember. I don't recall. It was the chairman who was making the statement. I don't recall whether he gave the names. Probably the document that he gave had the names.
Do you have a problem for the respondent to be released on bail?
Yes, I do.
I'm officially going to make an application for him to be released on bail. Why will you oppose bail?
Based on what I've stated in my affidavit.
I have taken you slowly of why you need him, and you have not proved any reason of him being with you physically.
That is your interpretation of my. That is your interpretation of my answers.
Well, we can now submit over. We are through with it, unless the state wants to re-examine their witness.
We can have the ruling on the
You know, we've not. There's an application I'm making now.
you're not yet.
No, we are not yet.
All right, that's it.
You know, the respondent wishes to make an application for him to be released on bail and reasonable bond terms. On the following basis, there has not been established any compelling reasons to warrant the respondent to be detained for 21 days. The respondent willingly submitted to the authorities when summoned. The respondent is a serving police officer. And the government has all the records. You know, you can discharge Jibril because we will take long to make our submissions.
All right. So you are done with him?
We're done with him.
I think you can now leave.
Thank you.
Thank you. Thank you.
Yes.
You know, there has not been any material placed before this court to show an attempt to interfere with the investigations. My other brothers and sisters here will deal with authorities that demand for that. You know, this detention of 21 days is a plea detention. Where the liberty and the freedom of the respondent the purpose of bail and bond is to ensure the attendance of the respondent before this court. Is plea detention the only option available? To the state. You know, that has been dealt by, in the case of Oscar Sudi, by then Justice Professor Ngugi. My other sheet should deliver that authority and put the citations very clearly. The state cannot now say it cannot prevent interference with witnesses. The Republic of Kenya is not a banana country. That the state is scared of a citizen being out. The mandate, the government of Kenya is to ensure everybody complies with the law. So the government cannot come to court that we fear he's going to interfere. That is a banana country that will tell people that we fear an individual is likely to interfere. If the respondent interferes, the bond terms will be cancelled and the state will come to court to show that he has failed to comply with the court orders. Your Honor, you are aware of the celebrated case of Michael Oyamo at the Court of Appeal, where the Court of Appeal was very emphatic that the court has jurisdiction, has power to impose conditions. And that is why we are seeking that the court imposes conditions of bail and bond. Your Honor, the fear of the state is a fear of a police constable. We urge the court to take judicial notice that people wielding massive powers in form of cabinet secretaries, sitting governors, heads of state at the ICC, when Kenyan leaders were taken to the ICC, they were released on bail. So that fear, Justice Kuril has dealt with that fear in the celebrated case of Dwight Sagare. The state must show by materials that the fear they are having is not mere apprehension. Then that this respondent can be released on cash bail, and the court orders he does not step. He does not step near Central Police Station. His parents are here, his relatives are here. He'll be confined to his home area until when the DPP decides to charge. Your Honor, we urge the court to stand firm and treat the respondent the same way all other accused people or respondents appear before you, so that it does not look that there is discrimination and there are two parallel laws for the mighty and for the constables. Your Honor, a mere statement that the police have a blue code of silence is not factual. It It is a statement made to hoodwink the court. The applicant IPOA is seeking 21 days to detain the respondent in a police station not manned by IPOA staff, manned by the same police officers. At one hand, IPOA is confident with the police that remand him in police station. In the other hand, it is telling you, Your Honor, the police have a blue code of silence. You can't speak from both sides. Your Honor, this country, as citizens of this country, every government entity operates within its mandate. We urge the court to find that there are no compelling reasons. Your Honor, the Judiciary Handbook on Bail and Bond, which the court is very aware, has provided for parameters to be considered for denial for bail. None has been presented before you. The applicant says there is a public uproar. There are demonstrations on the streets. This matter has gone to the Senate. It has gone to the National Assembly and the Commander-in-Chief of the Armed Forces, His Excellency President Dr. William Ruto, has talked about it. It is our submissions that out of that, this is a knee-jerk reaction to show everybody and the people are talking that we have arrested somebody. Your Honor, may you get favor in my submissions and allow the advocates with me to deal with the law and the authorities that will be supplying to court. I hope the state has been given those authorities. Thank you.
Right. Anybody else again?
Yes.